Greetings. My name is Srikanth Navale, and I'm an arbitrator having offices at Arna ADR, Maxwell Chamber Suites in Singapore. With that brief introduction out of the way, let me dive right into the subject. Despite its touted benefits of flexibility and speed, international commercial arbitration can be a long-drawn process. Even after obtaining a successful award, it is possible that an award creditor may be left with little to enforce it against. It is in this context that interim measures in arbitration proceedings become particularly relevant. Interim measures are, of course, of many kinds, but the ones that we come across most often are the ones ordering preservation or custody of property forming the subject matter of a dispute, or a freezing order, better known as the Mareva injunction. I assume, as students of law in a common law jurisdiction, most of us are familiar with these. But an area that has tended to be rather dynamic and generated considerable discussion is with respect to the ability of courts and arbitral tribunals to order interim measures in aid of foreign arbitral proceedings. Over the course of the next few minutes, it will be my attempt to provide you with a perspective on this, albeit briefly, from Singapore. Singapore has adopted the model law regime so far as arbitration law is concerned. It is the basis for both domestic and international arbitrations. The present focus is on the International Arbitration Act, which, as the name suggests, applies to international arbitrations. Under the International Arbitration Act, it is clear that both arbitral tribunals under Section 12 and the local courts under Section 12A have the power to order interim measures. For your reference, the measures that have been set out in Section 12A as applicable to the courts broadly covers similar ground as under Section 9 of the Indian Arbitration and Conciliation Act. On the question of whether such measures can extend to foreign-seated arbitrations, let me state at the outset that the matter is now quite clear that the courts in Singapore do have the power to order such measures. Section 12A 1B makes it clear that the powers under Section 12A apply irrespective of whether the place of arbitration is in the territory of Singapore. However, that wasn't always the case. Back in 2006 and 2007, there were two cases that examined this issue. The first was Swift Fortune versus Magnifica Marine at the High Court. Following the initiation of proceedings in a London-seated arbitration, the plaintiff in that case had obtained a Mareva injunction from a lower court in Singapore against the defendant's assets in Singapore. On appeal, the defendant sought to discharge the Mareva injunction. The High Court agreed, and it held that it had no power to make a Mareva injunction in support of a foreign-seated arbitration. The court concluded in that case that the International Arbitration Act only had territorial effect and therefore only empowered the Singapore courts to assist international commercial arbitrations that has their seat in Singapore. The second case at about the same time was Front Carriers Limited versus Atlantic and Orient Shipping Corporation. This similarly involved a London-seated arbitration, in aid of which the plaintiff had successfully obtained a Mareva injunction against the defendant's assets in Singapore. The defendant naturally appealed to have the injunction discharged before the High Court. In this case, the High Court reasoned differently. It reasoned that it had the power to assist international arbitrations, both in Singapore and abroad, on the ground that the provisions in the then International Arbitration Act drew from Article 9 of the Model Law, which had been incorporated into the International Arbitration Act. It held that the Article 9 provision provided for parties to seek interim relief from the courts regardless of whether the arbitral seat was in Singapore or not. While the court still didn't grant the Mareva in that case, that was on other grounds. So the High Court ruling in Swift Fortune, the earlier case, went before the Court of Appeals, where both the two conflicting High Court judgments were concerned. They were considered in length, I should say. The Court of Appeals considered the legislative history of the relevant provisions of the International Arbitration Act and Article 9 of the Model Law and concluded that it did not empower the Singapore courts to issue interim measures in aid of foreign arbitrations. It was reasoned that to conclude otherwise would be to, and I quote here, vest Singapore courts with wide-ranging powers that would cut across or intrude into the powers of the foreign tribunal conducting the arbitration under foreign law, and that such an approach would be contrary to the spirit of international arbitration. In the debate that followed, the key question was whether Singapore desired to follow a competitive approach or a reciprocity approach to international arbitration. The competitive approach would have likely been driven by two factors. First, that there were and indeed are substantial assets being managed by financial institutions in Singapore. If the courts were granted the power to issue interim orders in assistance of foreign-seated arbitrations, this could lead to an increased number of applications to the Singapore court for various interim orders against such assets. This could have led investors to move their assets out of Singapore and deter future investments here. Second, this could disincentivize parties from choosing Singapore as a seat of arbitrations, especially if they were allowed to gain access to Singapore courts for interim measures even without seating their arbitrations here. The reciprocity approach, on the other hand, was based on the argument that if Singapore did not confer its courts with the power to issue interim orders in aid of foreign-seated arbitrations, it would impact negatively on Singapore's standing as a pro-arbitration jurisdiction. This could affect Singapore's aim to be a leading international arbitration center, especially if other centers such as Hong Kong and London conferred such powers on their courts. In the end, the reciprocity approach won the day. Section 12 capital A was introduced in keeping with Singapore's position as a responsible international arbitration center and international commercial and financial center. It was interestingly recognized that the local business community will also benefit in that an award made in Singapore may be enforced in other countries which are parties to the New York Convention. Following these developments, the extent of the court's powers to order interim measures in aid of foreign arbitrations has been tested in a few cases. Prominent among these are the Maldives Airport Company Limited versus GMR Malay International Airport case and the Five Ocean Corporation versus Kingler Ship Private Limited case. In the Maldives Airport case, and on account of time paucity, we will focus on this one, GMR held a concession to operate the Malay airport. After deteriorating relations with the Maldivian government, GMR sought an injunction from the Singapore courts to prevent, the Maldivian government from taking over the airport. The dispute was subject to arbitration under UNCITRAL rules and was seated in Singapore. The Court of Appeals in Singapore held that while it had the power to grant the injunction sought, applying the well-known balance of convenience test as laid down in American Cyanamid, which you should be familiar with, it would refrain from doing so. Damages, the court reasoned, would be an adequate remedy if the arbitral tribunal were to find in GMR's favor. And second, there would be practical problems with enforcing such an injunction against the state. Let me now turn my attention to one of the more recent cases. This was in the context of whether a Singapore court retained the power to order a Mareva injunction in aid of a foreign court proceeding. While not strictly on the subject of international arbitration, this case throws light on the factors that Singapore courts could consider in the context of ordering Mareva injunctions to aid foreign arbitrations. The name of the case is B. Xiaoqing versus China Medical Technologies Incorporated. The Court of Appeals in this case examined and set out the extent of the court's power to grant a Mareva injunction against a defendant to Singapore proceedings, where at the same time the injunction is sought, the plaintiff intends to pursue or is pursuing foreign proceedings against that defendant, with the possibility that it will be the foreign proceedings that will culminate in a judgment. So let me explain. Briefly, the liquidators of China Medical initiated proceedings against the appellant in Hong Kong and Singapore simultaneously. to recover sums of money that have been allegedly misappropriated. The action against the appellant before the Singapore courts was one among these. China Medical, while commencing action, applied for a domestic Mareva injunction against the appellant. During the pendency of the various proceedings in Hong Kong and Singapore, China Medical chose to stay its Singapore action. Or rather, it applied for a stay successfully of its Singapore action. This was pending the determination of the Hong Kong proceedings. Nevertheless, China Medical chose to pursue the application for a Mareva injunction in relation to the domestic assets of the appellant. While the lower court held that the Singapore courts did have the power to grant a Mareva injunction under the circumstances, the matter was brought before the Court of Appeal. The Court of Appeal first reaffirmed the principles set out in the English Siskina case and held that the court must have in personam jurisdiction over the defendant and the plaintiff must have a reasonable accrued cause of action recognizable by the court. Subject to these restrictions, the court held that there was no bar on the power of the court to grant Mareva injunctions in support of foreign court proceedings. The court then went on to consider whether there is a requirement for the exercise of such power that the cause of action in respect of which the Mareva injunction is sought will terminate in a judgment in Singapore. In the present case, do recall that China Medical, while seeking a Mareva injunction from Singapore, had sought and obtained a stay in the proceedings before the Singapore court, pending the outcome of proceedings before the Hong Kong courts. The court, in this case, held, citing with approval the views expressed by Lord Mustill in the Channel Tunnel case, that the court retains residual jurisdiction over the underlying cause of action, even where a stay of that action is sought. This is because there remained the possibility that for various reasons, the dispute may eventually make its way back to the court, notwithstanding that it was currently stayed. This is different from a situation where an action has been struck out altogether rather than stayed, in which case, of course, the court will be deprived of any residual jurisdiction to grant interim injunctions. The court thus held that there ought not to be a further requirement that the cause of action in respect of which Mareva injunction is granted must also terminate in a judgment by the court. To conclude, the position in respect of the power of Singapore courts to grant a Mareva injunction in respect of foreign arbitral proceedings has been settled with the incorporation of Section 12 capital A of the International Arbitration Act, read with Section 12(1)(h) of the said Act. It is clear that the Singapore courts have the power and indeed are exercising such power to grant an injunction in aid of foreign arbitration. The recent decision in China Medical provides a pointer as to how such powers may be exercised by Singapore courts, especially in a situation where it involves a foreign arbitral proceeding as well as a local court proceeding that may have been stayed pending the outcome of such foreign arbitral proceeding. I hope this was useful to you. Thank you.